Welcome everyone, I'm Russell Alexander. I've been a lawyer at the team here at Russell Alexander Collaborative Family Lawyers for over 20 years. We help families going through separation and divorce. Today's topic, disinherited twins win 70% of estranged dad's estate. A father abandoned his twin daughters at birth and later disinherited them specifically, did not manage to stop them from inheriting the majority of his estate after he died. The history of the matter is quite unusual. Before the twins were born, the father suggested to the mother to get an abortion. She strongly opposed and went on to deliver the babies instead. Then when the girls were only 10 months old, the father abandoned them outright. The mother raised the girls on her own, but later died of complications from pneumonia when the girls were 9 years old. At that point, the father returned to try to wrest custody from the guardians the mother had appointed under her will. He lost custody, but was nonetheless awarded what the court called very generous parenting time with the girls, which he never bothered to exercise. Instead, he stubbornly decided to blame them for his unsuccessful custody bid. He formally abandoned the twins a second time, never once offering them financial support in the years after, even when formally disowned them out of anger and bitterness. He executed a second will in which he took pains to emphasize that they were illegitimate and to cut them out of any inheritance. The court explained that the fact he made it so clear in his first will and second will that the twins were illegitimate, he wanted no part of his estate to go to them, and has instructed his executors to fight any attempt to vary his will. Speaks volumes about his attitude towards them and his misguided and ill-conceived attempt to punish them for matters beyond their control. If you're enjoying this video and find it helpful, please give us a thumbs up or leave a comment below. The father died at age 66, leaving his estate to his two male friends. The twins, now aged 34, went to court to have the father's will varied. They were successful in obtaining an order to that effect. The British Columbia Court relied on legislation that expressly recognizes a deceased parent's moral obligation to provide for children. This is different from the law in Ontario, as illustrated in our blog, Testator's Freedom Make Even Unsavory or Distasteful Bequests Upheld in some cases. The statute empowers the court to examine the motives behind the father's steps to disinherit the girls, and this exercise led the court to conclude that his thinking and conduct was unreasonable in the circumstances. This is the British Columbia Court wrote, his rationale for disinheriting the twins is, as the court concluded, invalid, irrational, not based on what a reasonable testator judged by a contemporary community standards would or should have done. Indeed, the comments made about the twins in both wills were unwarranted, cruel, and untrue. They were not what a judicious father in these circumstances, discharging a moral duty to his children, would have said or done, especially considering the twins' difficult upbringing and considering they were the only persons owed a moral duty to. The court ultimately awarded each of the twins slightly over $300,000, with the remaining monies to go to the other named beneficiaries under the will. The court admonished the father, adding that before his death, he failed in his last opportunity to behave like a judicial father and recognize his moral obligation to the twins. To learn more about this case, you can read the full article in the link description below. Please leave your thoughts and comments below. If you liked this video and found it helpful, once again, please give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.